she can't stop people from firing these employees. She is literally usurping Trump's power to stop him from making these changes. Amy Berman Jackson, in her modification of the injunction, is inconsistent with the terms of the Court of Appeals, and therefore this is an abuse of discretion. Busted. The lack of judicially manageable standards in this posture is a reason to leave the execution of the laws to the executive, not to the courts, and so I respectfully dissent. A scathing dissent coming after an Obama judge. You remember her, Amy Berman Jackson. She was the judge presiding over this case. National Treasury Union, Russell Vought, is being sued by the Treasury Union. He runs the employees, right, Office of Management and Budget, and this union is suing Russell Vought. And what happened was Amy Berman Jackson came back down and issued this order from the District of Columbia and said, you can't fire anybody. Remember, we've seen all of these lawsuits about firing people. And a while back, in middle of April, Amy Berman Jackson issued this order saying to the Trump administration, you can't fire anybody, okay? The reduction in force that was announced by Director Vought is suspended, okay? You can't fire these people, so hire them back. And it may not be implemented or effectuated or completed in any way. The defendants are prohibited from discontinuing any employee's access to the work systems, including email and internal platforms, until the court has ruled on the plaintiff's motion. So signed by Amy Berman Jackson. Trump obviously appealed that, says, look, I'm the president. I want to fire people. I can fire people. These are lawfully appointed secretaries of the various positions, and they have the power, empowered by the American people and approved and affirmed by the Senate, to make these decisions. But what happened is the Court of Appeals from the District of Columbia came back down and they found in favor of the lower level judge. But the dissent, which is actually the much better analysis here, is blasting the judge. But here's a short order saying that Amy Berman Jackson can now be the president and stop Trump from firing people in his executive branch. Writing, upon consideration of the emergency motion, here's what they rule. It is ordered that the emergency motion be granted in part, saying Trump seeks clarification on this. Who can I fire and how? That term was not clearly defined. So we're going to define it now. A particularized assessment involves a determination conducted by a decision maker from the RIF with a declaration and more. And so we're also on our own ordering that this court's stay order be modified to lift the partial stay of this paragraph. So some things are changing, some things are staying. But our partial stay order determined and permitted them to conduct a RIF of certain employees whom the defendants have determined after a particularized assessment to be unnecessary for the performance of their duties. Now, they vigorously dispute this. Okay, who's necessary? Who's unnecessary, and all the things. Trump says any such judicial review, if you get to decide for us, you get to review what's necessary. Like, we think it's necessary to fire them. If you say it's not, then that means you're in charge of the agency, essentially. In response, they highlight that the proposed RIF involving 90% exceeds the scope. And given these ongoing disputes, we think it's best to restore this other paragraph to make sure that those other people are not being fired. So reinforcing this conclusion, we've accommodated this. We've got oral arguments coming up in 3 weeks. At that time, we'll talk about separation of powers and more. But right now, these people cannot be fired at the moment, right? Now, here, you can read through this, and we'll do it right now. But this is the dissent, which is much better in its analysis. They say, all right, listen. The panel today bars the political leadership of the Consumer Financial Protection Bureau from reducing its workforce in accordance with Trump's directives. Now, because this injunction was entered by Amy Berman, because it raises serious separation of powers concerns and has paved the way for ongoing judicial supervision of the executive branch, I would continue the stay pending the appeal. So she can't stop people from firing these employees. She is literally usurping Trump's power to stop him from making these changes. At the end of March, Amy entered a preliminary injunction stopping the CFBP from carrying out any reductions in force, freezing them under the previous administration's team. Now, the government sought a stay of the injunction. We granted that stay in substantial part, and it permitted the RIFs in conjunction with the law, so Trump could fire people. We expedited consideration of this and more. Now, the enjoined parties are the acting director and the political leadership of the government, appointed by the president, right? Trump appointed these people to do the job. With the injunction largely stayed, their leadership issued RIF notices to more than 80% of the workforce. That's a lot, right? So they're just cutting people. In a statement filed below, the agency's chief legal officer detailed the particularized assessment underlying the RIF and said the employees retained were sufficient, okay? We're not closing the agency. We're getting rid of 80% of people. We only need the remaining 20% to actually do the job. job, everything is in compliance with the law. He further clarified that the employees subject to the RIF would remain employed for 60 days. We would continually assess this. We'd make changes when necessary. But rather than wait to see if any harm materialized, the people suing here returned to the district court the same day that the RIF notices were issued. Okay, so they say, okay, you can fire these people. Trump does it. They say, what? This is unfathomable that you could continue to provide these required services if the RIFs were executed. Okay, so Trump says, hey, we can fire 80% of you and just get the job done with 20. They say, that's ridiculous. There's no way you can do that. It's unfathomable. But they didn't allege there was any specific harm or any loss of service. They just said, no way, like 80? That's crazy. Nor could they, since the employees subject to the RIF had not even stopped working yet, or less been terminated, right? So they got notice, so there was no harm. People are still working. They sued. Without any finding of particularized harm, the district court stopped the RIF. Again, although the district court styled this as a TRO, the label doesn't matter. They like to mislabel everything. I would construe, says this dissenting judge, the district court's order prohibiting the RIF as a modification of the injunction, and if the district court abused its discretion, then we have to vacate it. And in my view, here we go, Amy Berman Jackson and her modification of the injunction is inconsistent with the terms of the Court of Appeals, and therefore this is an abuse of discretion. Busted. The April 11th stay did not create a pre-clearance regime. We didn't tell you you could do this, Amy, or they must obtain judicial approval for its management decisions. We have to come talk to you about this? Unfortunately, that's exactly what's happening here. Amy has blocked a RIF while it determines by its own lights whether their staffing plans will be sufficient to fulfill the statutes, okay? She's in charge of the agency now. Well, that's too, you can't fire that many people. We don't need that many people. We need a lot more than that. You're not in charge. You don't run it. You don't know what's happening in the agency. The district court's approach turns the separation of powers on its head. The execution of the laws, including the management of agencies, is committed to the executive branch under the president. It's in the Constitution. It's the take care clause, requiring that the president take care that the laws be faithfully executed. And when the agency action is challenged, courts have an essential obligation to say what the law is. Whatever the merits of this underlying lawsuit, the district court cannot erase the boundaries between the courts and the executive by setting up a temporary receivership of the branch, right? Now, the court is in control of that agency. As the Supreme Court has admonished, it's not the role of the courts, but that of the political branches to shape the institutions. Courts don't run things. We do. While the April 11th stay left some parts of the injunction in place based on the government's concessions, it didn't authorize Amy Berman Jackson to inject herself into the day-to-day management, and so I would vacate her modification. Now, to the extent the stay was unclear, I would also clarify that Trump's actions, if they cause someone to lose services that are required by the law, then they can issue the relief. Like once the harm comes, then you can sue. But in the alternative, if a partial stay is truly unworkable, I would put an end to these cat and mouse games and stay the preliminary injunction entirely. Absolutely right. Saying, Judge Amy overstepped our stay, violated our order. Rather than remedy this error, today's order hamstrings the executive and prevents the CFPP from downsizing until the merits of the appeal are resolved. The lack of judicially manageable standards in this posture is a reason to leave the execution of the laws to the executive, not to the courts, and so I respectfully dissent. So Amy Berman Jackson kind of wins the day on that one. Of course, we'll see what comes next from Trump. Whether they take this up to the Supreme Court remains to be seen, but it's another case of another Democrat judge appointed by the Democrats to do the Democrat bidding is now acting like she's in charge of the entire agency. The dissent, of course, is the right analysis. Hopefully the Supreme Court steps in sooner rather than later to stop this madness. We'll be here continuing to cover it. Thank you for joining us as we do.